Welcome to Love, Money, and the Law. I'm your host, Cindy Hyde, and this is part of a series called The ABCs of Divorce. The subject today is how to get ready to testify for your divorce or a modification case. My guest today is Rick Goldberg, a trial litigation consultant and psychologist in Houston, Texas. Welcome.
Thank you.
So when Rick Goldberg is not conducting focus groups and mock trials around the country, you are working relentlessly to prepare witnesses to testify in hearings, depositions, or trials. He and his team do whatever it takes to build skills and confidence in witnesses so they are well prepared for the experience. Rick brings over 25 years of insight into our conversation today, and I'm very grateful to have the chance to talk with you.
Well, thanks for inviting me.
Yeah. So tell everyone, first of all, exactly what is a trial psychologist and a litigation consultant? I mean, what do you do in that capacity?
Well, really good question. As a trial psychologist, I get hired by attorneys, and here we're talking about family law. So in really highly contentious divorce cases, I get hired by attorneys to help level the playing field when their client has to testify either in a hearing, a deposition, or if a case actually goes to trial. So I work with them on really how to be the most authentic version of themselves that they can be.
Because going to trial or even taking a deposition is a very scary experience for most of us. I mean, that's not something we do every day. So, I mean, if I'm in that situation, I'm feeling nervous. I don't know what to expect. So these are some of the things that you could help me with in how to be my best self, like you said.
Right. Absolutely. I think the big emotion that people struggle with the most when they're testifying is fear and anger. Divorce cases just breed anger because typically one party doesn't want the divorce while the other one does. And then there's just a lot of fear as far as what's going to happen next. And when those two emotions are kind of running the show, you're never going to present the best version of yourself. And it's pretty critical that you do, because a person you don't even know, the judge or eventually a jury, is going to make a decision based on the impression that you leave with them. So it's like really important to be your best self.
So you may not have clients who have ever worked with a trial psychologist or a trial consultant before, or might not have ever had an experience in speaking with any sort of psychologist or even managing their emotions. So let's take an example. If I'm getting ready to testify in court and I'm getting ready to step into that witness box, what's the first thing that you tell someone to do under those circumstances?
Well, probably the first thing we do is we look at when that testifying date is and where we are today, and then we figure out how many times we can get together between now and then to get you ready. So that's probably the first thing. When I first started doing this type of work, literally dating myself 25 or almost 30 years ago, I did it a little differently. I would usually prepare someone a couple of days in front of an event, and we would work together for probably 6 or 7 hours, 2 days in a row.
Oh my. Okay.
And I found it was grueling, and it was daunting and extremely exhausting, and it had results, but it wasn't working as well. But then about 15 years ago, I was sued, and so I had to begin getting myself ready for being in the hot seat. And as a result of that, I realized that I responded much better to multiple 2 and 3 hour sessions. So the first thing we would do is figure out how many 2 or 3 hour blocks we can have with each other between now and your testifying event. So that's number one, create a schedule and create a calendar.
So what would be something that you could tell me, like what would be a tip that you would give me before I get ready to testify?
I would say one of the most important things You remember the movie The Wizard of Oz? Okay.
Sure.
And you remember how many clicks Dorothy has to do to get back to Kansas, right? How many?
3 clicks.
3 clicks. So I tell my clients one of the first things that they need to do after they listen to the question is wait 2 or 3 clicks before they answer the question. We want enough time to allow their attorney to object to the question, so we have to create some space. But then I need them to ask themselves, do I understand this question? So I want to give them time to do that. And then the research that I've done is I've found that fact finders, or which is a fancy name for a jury or a judge, they appreciate someone who waits a little bit before they answer versus someone who just immediately starts answering. The people who immediately start answering are viewed as a little bit more selling, like they're trying to persuade and sell. But the person who waits a moment or two, they have typically more humility. Looks like they're giving the question more thought. They're processing a little bit more, and they're doing a better job at trying to tell their truth. So that's a big reason why we like to wait a couple of beats, 2 to 3 beats, before someone answers the question.
That is great advice, really, for anything, anytime in a conversation. I mean, it could be in a business environment, but particularly in court or in a deposition, so you're not talking over one another or just get an emotional reaction, like you said. So it's really about how to take a pause and tell your truth or your side of the story and deliver it in the best possible way.
Right. That's a big part. Another key technique or a skill that someone needs to start mastering is the ability to be okay with themselves when they don't know the answer and when they don't understand the question, and when words are used in that question that they would just never say and would never use. You know, attorneys are really talented in taking depositions. They do it all the time. You've been doing it for a long time. So it's an unfair and an unlevel playing field. So I'm trying to give my client the tools that they need to go toe-to-toe and be able to lift their shield when they need to, lift their sword when they need to attack, or really make a point. But so that they can compete in that environment and just not get run over.
I think one thing that many people don't appreciate is that sometimes you can find yourself in these circumstances in a family law matter. If it's a divorce or modification or a suit affecting the parent-child relationship, you know, it's not uncommon to be called for deposition or to appear in court to testify, even you know, in a temporary orders hearing, or and also on final. So these are really excellent tips, and you know, I would think if I'm the one who's going to be testifying, you know, I'm happy to have your name right now to call my lawyer and say, call Rick, please. So one of the things that can happen in family law is that you can actually sort of snag yourself by creating bad evidence. And that can happen after the fact, even after a suit is filed. Do you want to comment on that a little bit for how it might pertain to you know, your role in the process, or how to help someone get ready to testify?
Sure. Family law is about 40% of my overall practice, but I'd say another 40% is commercial litigation, and the 20% is kind of white-collar criminal type litigation. And in criminal litigation and in commercial litigation, once a lawsuit is filed, there's typically never new evidence created. Everything is like from the date of the infraction back in time. But in family law, it's a significant difference. The day you file a lawsuit, everything you're now doing with your spouse or partner comes into play. And so it's critical that you don't create bad evidence for yourself. And one of the easiest ways to create bad evidence is to let your feelings be known in text messages and through softwares in family law that are typically used, like called My Family Wizard, or emails, any type of correspondence where you're critical of your spouse, or you show that you're doing things with your spouse that aren't in your children's best interest. That comes back and just kills you in court. Nothing judges frown on more than that kind of infighting, especially when it jeopardizes the child's relationship with one of the parents.
So let's say you have some bad acts that have been revealed in the course of a My Family Wizard conversation, and for those that are not familiar with that, it's type of software that the courts will accept as being the sort of neutral way to communicate between parties that is admissible in court as well. So let's say that things do get emotional sometimes, and this evidence is brought into trial. So if a witness has to be cross-examined, so what do you think a judge or a jury is looking for in a witness if they're trying to, again, show the best side of themselves and try to make the best impression, even though they might have had a moment that they regret in the course of their conversations?
Lots of regretful moments.
Yeah.
I think, look, it's family law, so
Right.
judges know that there is a lot of emotions and a lot at stake, and so they can be they could be somewhat sympathetic to those types of acts, but what they're not going to be sympathetic to, and what they're going to hammer the client on, is if they're trying to run away and spin what they did. So
Good
I don't
point.
create new spin for clients. That's their default. Their default is to try and figure out how to distance themselves, rework the situation so it kind of comes off like it really wasn't them. I mean, most people are very adept to blaming others. So I really work with people on how to take ownership and 100% responsibility and be accountable for their actions and start turning the corner immediately on it, apologizing for it. Owning it, talking about it, and talking about what they've learned from having done it that way, so they are better. So they're a better parent. So it's about, everything happens for a reason, or it wouldn't happen. I've kind of lived under that motto for many years. So what can I learn about myself, and how in this situation can I be a better parent having done that? And so that's what the court wants to see. They want to see that you're learning, that you're growing, and that you're not perfect and not trying to be perfect.
That's excellent insight and excellent advice. I think that's a great way to be supportive at any point in a trial, in a case, is just admit your mistakes. I've learned from my wrongs, and I'll try to do better. That's a great. I believe that's what you said. Yeah, basically. Yeah.
I have a current case I'm working in right now, and one of the parties just literally drives my client crazy and pushes her to the edge. And even though she is not supposed to drink while she has her children in her custody, and she's not a drinker, but she'll have a glass of wine or whatnot, she had a glass of wine or two, and she owned it. And the judge was completely okay with it, given that she can understand how her husband would push her, and that's her kind of her vehicle of which she numbs out and sort of gets right-sized. And so, she's like, look, try and do better. I understand, but I don't really want you drinking around the kids. And so she can get that, but that's how you turn a seemingly negative into a positive.
Rick, you've been involved with some very high-profile cases in your career. I'm familiar with Nicole Smith and the Andrea Yates murder case. Do you care to comment, or can you comment a little bit about your time as a consultant during those trials?
Yeah, I could say that whether someone is a celebrity or not a celebrity, everybody is nervous and everybody is scared when they have to testify and they don't know what they're going to do. And I'll give you, before I tell you a little Nicole Smith story, I'll give you a really good example of what this is like and how I experienced it a couple of years ago. So we all know how to drive a car, right? Pretty easy. I took my family, we went to England for spring break a couple of years ago, and I rented a car. And of course, I knew going in that I was going to be driving on the other side of the street and sitting in the other side of the car. But when I got in that car, I was petrified. I was so scared because I was so unfamiliar with driving on the other side of the road. Left-hand turns were right-hand turns. Right-hand turns were left-hand turns. I could never go in reverse. I just couldn't do it. I couldn't look over my other shoulder. I couldn't figure it out. And I could not parallel park. And I was just crippled and handicapped until about the 5th or 6th day. So it's a lot like testifying. I went into that experience very consciously knowing that I was incompetent. And most people come into the testifying experience knowing that they're pretty incompetent, right? Very few people have done it before. Then, after I practiced for a while, I drove around in a parking lot for a little bit, got a little bit more comfortable, I became consciously competent. So I knew what I had to do, but I thought about what I had to do a lot. And ultimately where I got to by that 5th day when I finally turned that car in, and I was so happy that I got to turn that car in, and where I like to try and get my clients is where they can be unconsciously competent, right? Just like breathing and just like the way we drive cars today out on the road. You don't think about what you're doing, you just have all that natural instinct. So I like to get them to a place where they can hear the question, and it's like seeing a slider or a curveball. You can see the spin of the ball, you just know what you're supposed to do with it because you know where it's going to break. Well, you know, I've been really fortunate through the years. I worked with all types of people. And Anna Nicole was a very astute client and very conscious of what she needed to do and what she needed to communicate in that case. It was a long case. It was exhausting and super tiring. And she did really, really well all the way through. But then, here's what happens. It's like it's never over until it's over. Rusty Harden, who's a very gifted attorney, finally pressed a few buttons, and not, I think, intentionally, but Rusty just knows what he's doing and knows what he's trying to accomplish. And all of a sudden, Anna Nicole got triggered and inflated and started calling Rusty by his first name on the witness stand. And from that point forward, she was just done. She was devastated, and she couldn't recover from that, and lost a lot of credibility throughout that particular portion of the trial. And so that's why it's, you know, it's like testifying is like running a marathon, but you just don't know when the 26th mile is. You just don't know when it's going to be over, and it's always, you're always most vulnerable 5 to 10 minutes before it's over. You just don't ever know when that 5 to 10 minutes is.
And sometimes the lawyers don't either, because one question leads to the next question, and if there's an opening, then you can sometimes walk right through that opening and continue your questioning, and that can wear you down very quickly. You know? Absolutely correct.
Now, I'm married to a divorce lawyer, and I can tell you one thing, that divorce lawyers will, well, any kind of lawyer, I don't want to just say divorce lawyers, but they will ask bad questions because they're thinking a million miles an hour and they're trying to put their things together, and they don't always try and ask an incredibly confusing question with a lot of strange context and things like that. Sometimes it just comes out that way, and it's really important that I communicate to my clients that when you hear questions like that, just be comfortable in saying, gosh, I'm sorry, I don't understand your question, and let them fix it.
Right.
Okay, don't do their work for them.
Right.
So that's going back to, I guess, technique. That's another really important technique that someone can use.
Well, that little, click 3 times and pause also gives your own attorney an opportunity to jump in and object if that's appropriate. So I think it's very smart to be able to learn how to manage that timing.
Right.
All right. And is there anyone else you'd like to give us some insight into, or any other cases that come to mind?
I sign non-disclosure agreements on almost
I know
every
you do.
case, but really, I have to honestly admit, I really do love working with the people that I work with. I have not fired, I don't think, a client in my tenure, and I know that everyone has like a part of themselves that a jury or a judge would love to see. And part of my job is to figure out how to help the client remove the cloud cover that hides their best attributes so that we can all see them and that they can testify from that place. Even like the most narcissistic, arrogant, extreme, angry, resentful people, somewhere in there is like a beautiful spot. And if we could find that spot, and if they could testify at least from that place, they'll get their truth across in the best way possible.
That's great. Get to the heart of the matter. Yeah?
The heart of the matter. Don Henley.
Yeah. Thank you, Rick. Appreciate your time.
Thank you, Cindy. I appreciate it.
That's all for now. Thank you for joining me for this episode of Love, Money, and the Law, and my special guest, Rick Goldberg, a trial psychologist and litigation consultant in Houston, Texas. I'm Cindy Hyde. Until next time.